for the last 2 weeks of having 3 jury trials set within a 2-week span. So it's just been spread through at our office on our side, Judge. And I know I'm not trying to argue that lawyers aren't busy, but it's been hard to get to this one on top of the other 2. I'm on call right now with Judge Purdy since last Monday, which is another jury trial. She told me today, because we came back down today, she doesn't expect me to get called this week, but I don't know. So all that, Judge, it's just we've been preparing for all 3 jury trials.
Is this case going to take to try? Because you guys are going to be called down. So how long is it going to take to try?
I'm not sure with Ms. Thompson for the plaintiff, Judge, but I don't expect us to be longer than a day on our side.
It would be the same here, Your Honor.
Ms. Thomason, we can barely hear you. If you could speak up a little bit.
It would be the same expectation here, Your Honor, no longer than a day.
So 2 days total or just 1 day total?
I think 1 day total.
Okay.
Am I right?
Have you guys already conferred on your motions and limines?
No, Your Honor.
No.
We've not done anything together towards the case. We're just waiting.
But for tomorrow, if you guys can confer on your motions and limines, confer on your exhibit list. We start at 9 in the morning. Do you guys have any questions?
Just procedurally, so we'll have just a little pretrial with you on the motion of limine, and then probably the jury, and then expect testimony. Would it be right in the morning, or would we probably do something?
How much time do you need? This is a property case, is that right?
Breach of contract. Breach of contract case.
Okay. I mean, how much time do you want for voir dire? 20, 30 minutes? What do you want?
Ms. Thomason, I would say 20 minutes probably for each side would be fine. Ms. Thomason, if you agree.
I think 20 minutes would work for me too, Your Honor.
So it depends on how quickly we can get the jury from downstairs, but I think we probably will definitely get to openings with 20 minutes for voir dire. We might get it to the first witness before we do lunch. And is there any chance this case is going to settle? Have you guys been to mediation and all that?
We did mediation quite a while back, Judge. Me and Ms. Thompson will probably get on the phone here in a little bit. Maybe, I don't know. I'll talk to her. There may be a chance, Judge, but it's been a little while since we've talked about this one.
Okay, well, if it does settle, let us know, and we will see you guys in the morning. Do you have any other questions?
Not on my side, Judge. I appreciate it.
Fine, Your Honor.
All right, you guys will see you in the morning, okay?
Okay, thank you.
Judge.
All righty. I know that there's we're going to jump to Benz versus Martins, DC 22-16240. Ms. Jobin, are you here?
Yes, Your Honor.
And is Ms. Benz here?
Yes, Your Honor.
Yes, she is. There she is.
And then Mr. Hatcher, are you here? Is it anyone here with the defense?
I do not see Mr. Hatcher here, and he had confirmed that he was available at this time last week. And so we got the link from Ms. Pinson. So I'm not sure where he is. I mean, I can fill you in on I don't know how much his input is going to be required for the purposes of your guidance on what to do with this situation.
Sure. Tony, are we on the record?
We can be.
All right, let's just go on the record. It's this is DC 22-16240, Benz versus Martin. As the guardian ad litem can make her announcement.
Lauren Jobin as the guardian ad litem.
And then Miss Benz, if you could state your name for the record.
Abrisha Benz.
And the defense attorney was notified of this hearing. He's not here. Hopefully he'll join us soon. This is just a status conference. So Ms. Jobin, if you could just kind of tell me what's going on.
Yes, Your Honor. So the situation is, as far as I can tell, this I've not encountered before, there is no agreed settlement. So there was no plaintiff's counsel at any point, or maybe there was. The incident occurred in Arkansas. the biological custodial parent is Miss Benz, who was on this hearing. So she's as a representative of the minor, Logan Mobley. Father of the child was involved in the wreck. He has previously settled out in Arkansas. So I believe
Arizona.
Arizona, I apologize. So, but he's already been dispersed and paid out. I'm not sure. I don't really have any knowledge with respect to that. And as far as I understand, nobody really does. But the situation is that settled for Geico was 30,000, U-Haul 25,000. There's no agreement as to either one of those. There's no signed settlement agreement and release, which is a total settlement of 55,000.
Is that for the minor or is that for the adult?
That's just for the minor.
Okay.
Yeah, I don't have any knowledge on what the father settled for, but of that 55,000, of which there's no real agreement, the two bills, I've got a helicopter lien for care flight that's $54,267.25, which is, just shy of $50 less than the total settlement, and that's a sub-row. And then a hospital bill of $32,623, which puts me at about $90,000 on a $55,000 settlement. However, it says the patient qualified for FA and the bill was zeroed out with respect to that $32,000 amount. So I just want to be clear on that. When it comes time for prove up, I'll keep running lien searches. I'm not sure if you want me to just, from what I'm understanding, I'm going to have to negotiate down this lien because there is no plaintiff's counsel, right? Otherwise, she would have to seek counsel to do that on behalf of the minor, who would then take a third or 40% or whatever that would be of the total settlement fund.
Or Ms. Benz can do it. It's either of you. It's not really your job to do it. You're here to just advise me on whether or not the settlement is in the best interest of the child. I wish that opposing the problem is the defense attorney. It might be best to get the defense attorney on the phone, because if you're going to be doing anything beyond that and charging the defense attorney for it, I want to make sure he's not objecting, because it's really not your job to negotiate that. It's the job of either the plaintiff's attorney or the plaintiff.
Well, I will tell you, I can try to call him on his cell, but I will tell you that that he has indicated in numerous emails that he had an impromptu discussion of this with you, and that he's indicating he wants me to reduce that stuff.
Okay.
He wants me to handle it. So
That's
that's
okay.
I wanted to make sure that's what you wanted me to do, and then kind of explain to Ms. Benz that I'm not her counsel of record specifically, because I think there's been a
Of
little
course. Yeah,
confusion.
you are here to represent the interest of the child only, and advise me on whether or not this settlement is in the best interest of the minor. If you determine that it's not, and I agree with you, then the settlement would not go forward.
Okay.
Ms.
Do you have
Benz, did you have any questions about that?
Just a little confusion, because I asked Mr. Hatcher, because I've never had an occurrence with this type of situation. So I asked Mr. Hatcher if I needed to hire someone. And like in the beginning, before Ms. Jobin ever came in, he told me no, that they would be paying her and that she would be my lawyer. So he did state that to me previously. So I've made a couple phone calls, and people have been telling me they can't take the case because it's so far along now.
So let me just say this, Mr. Hatcher, if he said that was incorrect. Miss Jobin is not your lawyer. And so if you feel like you need a lawyer, I don't really know enough about the case to know if you do need a lawyer or not. The lawyer is going to take a percentage in all likelihood of whatever you recover. So it's a little tricky, but Miss Jobin's role is fairly limited, which is to advise us on the amount of the lien advise us on whether or not the settlement is in the best interest of the child. If you feel like you need to get a lawyer for your child, or for you and your child, that's perfectly okay. It's just, it may be economically better not to do that, given what's going on. I'm not advising you, because it's not my role anyway. But we do need to kind of figure out if you feel like you do want to try to find a lawyer. And one thing the lawyer can help do is negotiate a higher settlement if that's appropriate. I don't know enough about the case to know what the value of this case is. But if it is appropriate to, you might be able to get a lawyer here to, push for a higher settlement. That's not Ms. Jobin's role. She's here to advise me and to, on whether or not this is in the best interest of the child. She's not really here to do all the other stuff a plaintiff's attorney would do. Does that make sense?
Yes, that does make sense. So I need to get a lawyer to make sure, because as of now, the settlement doesn't even cover his medical bills. So that means I would need a lawyer, correct?
I'm not saying that. I'm not saying that. I don't know that you do or you don't. I just want you to understand what Ms. Jobin's role is.
Yeah, I understand.
And Ms. Jobin, if you don't feel like this settlement is in the best interest of the child, you need to tell me that. And then we go back to the drawing board and figure this out. That's between.
Yeah, and the thing is, Your Honor, I mean, the reason that's difficult is because there was no plaintiff's attorney, there's no medical bills, there's nothing for me to review other than medical records, rather, to see kind of what the damage is. And it's my understanding there's policy limits, but I don't have any deck pages. I just don't have a lot of the typical information that would have been
You would
provided.
usually get from the plaintiff's attorney.
Right, yeah. So, I mean, let me have a conversation with Colin. As it stands, I guess we're kind of at an impasse on whether Miss Benz wants to get counsel or not. I mean, but I will say statute will be running on this in under 90 days. So if that was the case, just, as if I was
Yeah, you probably.
Mhm.
This is a tough call, Miss Benz, and I just want to make it clear, I'm not advising you need attorney. That's not what I'm saying at all. But I do think that you need to understand Miss Jobin's role in this, which is very limited, which is to advise me on whether or not this case is this settlement is in the best interest of the child. So it's up to you to make that decision. You obviously, Miss Jobin has said that you need to do that very quickly because the statute of limitations on at least part of this claim is going to run pretty soon. How old is the child?
He is 9.
9. Okay. All right.
Well, thank you, Your Honor. I think I'll go ahead and call, I'm not sure where defense counsel was today, but I'll give him a call, and then Ms. Benz, I'll speak to you when you get off work this evening to kind of figure out, since I think we made some progress. Thank you, Your Honor.
All right. You guys have a great rest of your day.
You too. Thank you.
All right. SL4 Wood Waterside versus Wood Waterside. Is anyone here on that case?
Good morning, Your Honor. Bo Cox with Norton Rose Fulbright.
And where's your opposing counsel?
Your Honor, my opposing counsel is Robin Harrison. I don't actually see him on the video conference, though I believe it was his office that noticed this hearing.
Okay. Well, is it his hearing or your hearing?
Your Honor, technically speaking, it's a joint request for an abatement arising out of a guarantee case in which we have been actively arbitrating 2 underlying arbitrations. I don't think this case is ever going to get tried. We just got the award and it rejected the plaintiff's claims. Nonetheless, we have 45 days to work out the payments there in accordance with the arbitration award. And so I think we're really just looking to save the parties time and money in connection with this June trial setting while we effectively just pay out the awards.
So what I guess I don't really understand here is, has the entire case been arbitrated, or is there you said there's a guarantee aspect of this that was not arbitrated? Is that correct?
Your Honor, yes, just for clarity, it'll take 30 seconds to explain. There's one group represented by Mr. Harrison's clients, and that group is the plaintiff, or group of plaintiffs in this guarantee case. They filed an underlying arbitration related to the development of some multifamily real estate projects. The panel rejected all of their claims. And so consequently, the guarantees that they're suing on here will never be triggered nor relevant. If this case were to be abated and for some reason the plaintiff group declined to simply non-suit them once the panel's order period, it's still in its review period right now, technically. Once that were to expire, we would simply file a motion for summary judgment and the case would go away. So
All right.
all we're looking.
What I'm going to do in this case, and it's set for trial in June. Rhonda, are you there? Rhonda?
Yes, Judge, I'm here.
All right, go ahead and reset this case for trial. I'm going to give them some extra time. How does you want to set it in October?
That'd be just fine, Your Honor.
Okay, let's reset this to October 10th.
Okay. And what's the name of this case?
It is SL4 Waterside versus Woodwaterside. DC 225080. But is it
Send that to December 4th.
Mr. Harrison is signing on? I don't know why he's quite so late, but let me.
Was that correct with the trial date, attorneys, December 4th, 23rd?
So wait, when is it set right now?
It's set for June 20th. I believe you were resetting it to October 10 was what you said.
Yeah, well, let me talk to Mr. Harrison. He's just finally joined us.
Gotcha.
Mr. Harrison, you almost missed the hearing.
I apologize, Your Honor. I had an issue this morning, but I'm with you now. Thank you.
All right, so we had a brief talk with opposing counsel. He had suggested maybe abating the case. I don't think that's necessary. So I was going to reset, but I do agree we don't want to have the trial setting next week. So I was going to reset it to October 10th.
I think that's perfectly fine, Your Honor. I think the likelihood is that things will be resolved well before that. So resetting the trial for October would be fine.
Okay, perfect. You guys have a great rest of your day, and good luck with getting this case resolved, okay?
All right. And Your Honor, again, thank you for your patience with my delay.
No worries. You have a great rest of your day.
Thank you.
Okay, Savannah at Lakeview LP versus Encore Electric Delivery Company LLC. It's a scheduling conference. Anyone here on that case?
Yes, Your Honor, for the plaintiffs, Logan Adcock.
Okay. Anyone here for the defendants? You're with Justin Ratley's office, is that correct?
Correct.
Have you guys already submitted a scheduling order?
No, we haven't. There was a pending motion on a somewhat related case in Judge Williams's court, a motion to consolidate for discovery purposes only. We got an order back last week denying that. And so we just need to put our heads together on a scheduling order. I think we can get it to you pretty quickly.
All right. When we're going to go ahead and set this for trial. So when do you want to set it?
We were thinking fall of 2024.
Okay. Let's pick a date.
Okay.
September 10th, 17th, 24th.
If they can see you, Mr. Lewis.
I'm sorry.
I'm not sure. Rhonda said something. Don't worry about it. September 10th, 17th, or 24th.
I'm just checking my calendar. It looks like September 10th is perfect.
All right. Well, Rhonda will set this for trial on September 10th. And
Okay.
then which mediator do you want to use?
Well, I can select someone now, or I think my counsel on the other side will probably want to have some input, and I think we can come to an agreement.
We're going to go ahead and appoint somebody, and then you guys can move to substitute if you'd like, but we're going to pick someone now. So who would you like?
Well, let's go with Paulo Flores.
Who?
Paulo Flores. He's a construction attorney in Dallas, Epicard and Abramson, or we can go with one of the just strict mediators. Jeff Abrams would be fine.
You want to do Jeff Abrams or King Viper?
Let's go with Jeff Abrams.
Okay. I mean, I just don't know this Paulo Flores person.
Okay. Sure.
But nothing against him. I just don't know him. So we'll go ahead and appoint Jeff Abrams. And if you want to substitute him out, you just have to follow agreed motion to substitute mediator.
Excellent.
All right, anything else we need to chat about, Mr. Adcock?
Nothing for me.
All right, we'll go ahead and set this for trial on September 10th, and we'll appoint Jeff Abrams.
Thank you.
Got it.
All right, you have a great rest of your day, Mr. Adcock.
You too. Thanks.
All right, Mahomes versus Francisco Eduardo Salinas. Anyone here on that case?
Yes, sir. Chandler Wallace for the plaintiffs.
Damian Perez for the defendant.
All right, and you guys have an agreed scheduling order on this?
We have one that we've been working on. It has not been submitted, but we have an agreed DCO that we think we could get in place.
All right, when is the trial setting?
We have it set for April 23rd, 2024, starting at 9, if that is amenable to your calendar.
2023, you said, or 2024?
2024.
Sorry. Let me just check. Is that okay with you, Mr. Perez?
It sure is, Judge.
Let me just make sure we don't have a special setting that week. I don't have any conflict that I know of, but let me just double check. Yep, that looks good. April 23rd. It'll be April 23rd, which is a Tuesday. Let's pick a mediator. Who do you want to use?
Mr. Perez had a few recommendations. Mr. Perez, what were those names again?
Oh, it was the likes of Kevin Walker, Jay Zaleski, Martin Terry, Jim Hitzelberger.
Is this a car wreck? What is this, a car wreck?
Yes.
Yes, sir.
I don't know that the first person you said, I don't think, but the rest of them I know, they're all good mediators.
Okay, you said Mr. Terry, Mr. Perez?
Yes.
Okay,
You want to go with Martin Terry?
that works with us.
All right, let's go ahead and appoint Martin Terry on this one. Anything else we need to chat about today, guys?
No, Judge, the only question I have is where would you like us to send our proposed scheduling order?
Go ahead and e-file it and then email it to Rhonda.
Perfect. I will go ahead and do that.
All right, you have a great rest of your day, guys.
You as
Thanks,
well.
Judge.
Thank you, Judge.
All right, Vega versus Moon, DC 22-16950.
Defendant is here and present, Your Honor, Byron Woolley.
Your Honor, I'm Mike Brummett for the third party defendant. I'm present. My understanding from Ms. Redden, Vicki Redden, who represents the plaintiff, she's in her legal assistant said she's in a temporary orders hearing in Dallas right now. She was hoping to break free. Maybe we'll see her momentarily. Maybe not.
When do y'all want to set this for trial?
Mr. Brummett, what do you think about like April or May of next year?
Yeah, late spring, summer of next year probably seems fine. We've been in this suit not too long, so I'm trying to think it's primarily a dispute between Ms. Redden's client and yours, but I take it y'all have not discussed trial dates.
We have not yet.
Well, we want to do May 7th, May 14th, May 21st, May 28th.
Judge, if we could, let's do May 7th. I'm having a 50th wedding anniversary on May 17th, and I'd like to have this trial out of the way so I don't have the needs for Miss Redden's talents shortly thereafter. I'm in the middle of trial on the 17th.
I think that's a good idea. Congratulations. That's amazing. My wife and I had our 31st recently. And so that's amazing that you guys have been married that long. Congratulations.
Thank you.
All right. So does that work for you, May 7th?
Works for me, Your Honor.
All right. And then if Ms. Redden has a big problem with that, you guys are welcome to sign back onto the Zoom later. Who do you want to use as a mediator?
Mr. Brummett, what do you think about either Suzanne Wooten and Ashby? I think maybe a former judge in this case might be useful for our clients. I've used both of them over the years. I found it to be good mediators. So obviously Jay Zaleski is good.
I'm not as familiar with Suzanne Wooten. I know Ann Ashby, obviously. King Pfeiffer is good at these kind of things too.
Pfeiffer.
But it's up to y'all. I mean, I whoever you guys can agree on.
I'd say King Pfeiffer, Judge Wooten. Either or.
Mr. Woolley, what do you prefer?
Let's go with King Pfeiffer. I think that seems to be, the court knows Judge Pfeiffer better than Judge Wooten, and it makes everybody happy.
If you're okay, have you mediated with him before? Do you like him?
Yes, no, he's perfectly fine.
Okay, let's go ahead and appoint King Pfeiffer on this one, and we're going to set it for May 7th. And congratulations again. Anything else we need to chat about today, guys?
No, Your Honor.
I don't believe so.
All right, you guys have a great rest of your day.
Same to
Thank
you,
you.
Jeff.
Have a good day.
All right, I don't see them here. Is anyone here on never know how to say it's Pius versus Anderson Homes? Anyone here on that case? Mr. Casey, I think you're here on Williamson versus Premier.
That is correct, John.
Security, and is your opposing counsel here?
Yes, I'm here, Your Honor.
All right. Rhonda, let's go on the record on DC 221636, Williamson versus Premier Protective Security. Counsel, make your appearances.
Cornelius Casey for plaintiff Darrell Williamson.
Emma Martin on behalf of defendant Premier Protective Security.
All right. You may proceed.
Your Honor, this is a case where it was an assault, and we filed a lawsuit. The assault was done by a security guard that we allege is the employee of the defendant, Premier Protective Security. When we filed the lawsuit, we did not have the identity of the individual who has come to be known as Mr. James Ellis White. So at the time, we just filed the lawsuit as Premier Protective Service and an unnamed security guard. All throughout our original petition, we just put forth our allegations, but without a name as to who committed it. But we make it clear that we are going under the premises of respondeat superior, that Mr. Ellis, Mr. White, at all times that are pertinent to was an employee of the defendant Premier Protective Services when he was in the act that caused us to be here today. And we were just wanting to get motion for leave of court just to name Mr. Ellis White. I understand the counsel has said that the statute of limitation has expired, and it did. In fact, statute of limitation expired probably like a week or two after the lawsuit was filed, even before the response. But we don't think that by naming him in the petition in any way prejudices the defendant's case. It does not come as a surprise. In fact, we only found out the defendant's name once they disclosed who we suspect to be the unnamed security guard in their disclosures. And so we just feel that it's not a statute of limitations issue. It's an issue as to whether or not in any way us naming him, just putting him on the petition in any way destroys our lawsuit or the case or that defense. And we submit that it does not, that it is a harmless addition.
So there's, to me, two different issues. One is, can you amend your petition to add this? Yes, you can, I would think, but separate issue, not there's a valid statute of limitations. That's a different issue that would need to be resolved through some other way. But Ms. Martin, what is your thoughts?
Yes, Your Honor. As we set out in our response, I think the case law on this issue is that when the statute of limitations has run, it doesn't toll the statute as to an unnamed party. And so amending at this point after the statute of limitations has run to name a John Doe party is improper. So for that reason, we would oppose that.
All right, I'm going to grant the motion for leave to add them as a party. That is, it doesn't mean you can't raise a statute of limitations defense.
Thank you very much, Your Honor.
But, all right, so have you submitted an order on that?
I think we have. Yes, well, we have submitted an order. It's on file.
Gonna coordinate, contact your son, and she's gonna let him know when she's gonna be there to move stuff out.
Sorry about that, guys.
I thought I was only one seeing that.
All right, let's see. Let me see if we have an order real quick.
I think it was at the end of their motion.
Okay. Okay. Rhonda, are you there?
Yes, Judge, I'm here.
So let's see. There was a motion to amend petition in this case.
Okay.
I'm going to send Jake back to get it. Let me see. There is no order attached. Let me see.
Almost certain we sent one.
You did, yeah. Okay, Rhonda, it's not attached, but look at 5/4/23, the proposed order to amend petition. Can you print that out? Jake's going to go get it, and if you could just bring it to me so I can sign it.
Okay.
All right. Anything else today, guys?
No, that'll be all, Your Honor.
All right. You have a great rest of your day.
All right, you too. God bless. Take care.
Thank you. You too.
Miss Redden, you missed the hearing on this case. You're welcome to call opposing counsel. Let me tell you what we did, and you can decide if you have an issue, if you want to. Can you hear me okay, Miss Redden?
Yes, I can, Your Honor.
All right. So we set this case for trial. And again, you can call opposing counsel if you want to get them back on the Zoom for May 7th, 2024. And we appointed King Pfeiffer as the mediator. If you have an issue with that, I'm happy to. You just weren't here. We weren't sure what was going on. So
I'm sorry about that. Mr. Brummett was supposed to let you know I've in another hearing that's taken longer than it was supposed to. So I apologize. I wasn't ignoring you.
No, it's okay. Does that work for you, May 7th?
That does.
And then King Pfeiffer, the mediator?
Yes, sir.
Okay. All righty. And if you guys want to substitute in a different mediator, you can, but we'll go ahead and start off with King Pfeiffer. And Ms. Redden, good luck with your hearing today, okay?
Thank you so much, Your Honor.
It's going to be set for trial May 7th of 2024.
All right. Thank you very much.
Thank you. You have a good day.
Thank you. Same to you. Bye.
Okay. So